side will have 15 minutes, and the appellant may reserve up to 5. And just let me know if you want to reserve time.
Okay. Good morning, Your Honor. This time, may it please the court, I would like to reserve 3 minutes for rebuttal at the end of this argument. My name is Attorney T.J. Murray. I represent the appellant Michelle Hace in this matter. This morning there are 3 issues for review, 2 primary issues and a third that kind of results from the first 2. The first issue is whether or not the officer's initial approach to the vehicle in this case was a valid execution of the community caretaking function. The second issue is whether the continued detention of the appellant was appropriate in light of the totality of the circumstances. And then the third issue kind of results from those 2, whether there was probable cause to arrest the appellant for being in actual physical control of vehicle while under the influence of alcohol. The facts in this case are important. The appellant had just gotten off of work. She's a manager at Johnny Malloy's bar in Medina. She had finished up her paperwork after the bar closed, went to her car. It was approximately 4:59 in the morning on the date of the offense. Officer James Terwilliger of the Medina Police Department was driving past the bar, noticed a car in the parking lot with its headlights on. No other cars in the parking lot. Officer Terwilliger pulled in the back entrance of Johnny Malloy's, pulled in behind the appellant's car at approximately a 7 o'clock angle, activated his emergency light, did not activate the overhead red and blue takedown lights. Approached the vehicle, knocked on the window. Ms. Hace rolled the window down. Officer Terwilliger immediately said, what are you doing? Was his first interaction with the appellant. Appellant explained that she had just gotten off work, finished her paperwork, and was defogging her windows. Officer Terwilliger noticed a smell of alcohol emanating from the vehicle, asked Ms. Hace why there was a smell of alcohol coming from the vehicle, to which Ms. Hace replied she didn't know, other than that she works here at a bar and had been pouring drinks all night. Officer Terwilliger asked Ms. Hace to provide her driver's license, registration, insurance information, to which she did. At no time during this exchange did Ms. Hace noticeably stumble over words, slur speech, fumble with her belongings. She provided Officer Terwilliger the information he asked for. Officer went to his car, ran the registration and license, went back to the vehicle, asked her to step out, proceeded with field sobriety tests, after which he arrested her for being in actual physical control of the vehicle. The trial court in this matter concluded that the officer's initial approach to the vehicle was a valid execution of the community caretaking function. I think it's important that we realize that that's what the decision of the trial court was. The trial court did not determine that this was a consensual encounter between the officer and the defendant. They determined that the officer was executing his community caretaking function. The law is pretty clear on community caretaking function. In this case, this court addressed it in State v. Clapper in 2012 case, in which this court clearly laid out what the test was, and that an officer must be able to point to reasonable, articulable facts upon which to base his or her safety concerns. In this case, Your Honors, the officer testified repeatedly that this was a suspicious vehicle. On cross-examination, the officer testified that he had come across parked vehicles at this time of the day before, and many times the occupants were engaged in either drug activity or sexual activity. And that this was a suspicious vehicle that he felt the need he needed to check out what was going on. His first words to the defendant upon her rolling down the window were, "What are you doing?" His first words were not, "Is everything okay? Do you need any help?" It was, "What are you doing? Why do you smell of alcohol? Let me see your license, registration, and insurance."
Well, let us assume that even though the court couched its opinion in terms of this being a community caretaking function, let's just assume, and that when the officer approached the driver's window, that as soon as she rolled down the window, he detected the odor of alcohol. Does that not give him the additional evidence to begin to investigate at that moment?
Your Honor, respectfully, I would say absolutely not. There's obviously a lot of case law on consensual encounters and what is reasonable suspicion, and obviously we're probably all going to be trying to figure that out for years to come, right? But in this matter, it's important to say, when did the investigation start? Because I don't think that it's possible that in the time that the window came down, and his immediate words to the defendant, "What are you doing?" Which, to me, Your Honor, evidence is that this was an investigatory stop, whether it started when the window rolled down or prior. Well, it's not, I shouldn't say a stop, Your Honor, an investigatory approach
So he didn't
of the
really need
vehicle.
reasonable suspicion to stop because there's no stop.
Well, and Your Honor, if the officer had approached the vehicle with the intention of finding out if the defendant was okay, then we probably wouldn't even be here on this issue. That's precisely why we're in front of you on appeal, is because the officer's intention was clearly not to find out if the defendant was okay. The officer's intention.
I'm not sure that his asking the question, "What are you doing?" is necessarily inconsistent with his determining whether she was okay.
That's
Just because he didn't say the words, "Are you okay?"
Mhm.
If you come upon a vehicle in the parking lot of a closed business at a very, very late hour, the question, "What are you doing?" may lead to, is there somebody else in the area? Are you stranded? You know, but it doesn't seem to me that it's necessarily inconsistent with community caretaking.
And I would agree with you, Your Honor, but to a point. I mean, when we look at the totality of the officer's testimony, I believe he answered a question very late in the hearing that was asked of him, could there have been somebody inside that was ill or hurt? I think he said yes to that. However, when he was being questioned as to his purpose for approaching the vehicle, his response was, number one, it's a suspicious vehicle, and then on top of that, in follow-up, again, when he was asked, have you ever seen parked vehicles with their headlights on or off at that time of day? And his answer was yes. And what did you come across when you approached those vehicles? There were people engaged in sexual activity or drug activity. The officer didn't even testify at that point that, yeah, sometimes there's people who just need help. His testimony was, essentially, we've had issues with finding people engaged in these illegal activities, and that's what made this vehicle suspicious to him. And then on top of that, and that's why I say, on top of that, for him to approach the vehicle and ask immediately, what are you doing? And the next question is, why do you smell of alcohol? It certainly, along with the car being outside of a bar, Your Honor,
Well, you told me that, you said that he approached the vehicle at 7 o'clock position. Can you describe that better for me?
Yeah, Your Honor, he pulled, I'm not sure if you know the layout of Johnny Malloy's parking lot, but he pulled in a back exit, yeah, and pulled up to the car roughly at a 7 o'clock angle. So if our car's sitting here, the officer was angled at about here.
So it wasn't behind the car or next to the
He
car?
was
but
not-
There was room if
was
she wanted
not
to back
direct-
up and leave, she could have backed up.
That's correct, Your Honor. He was not directly behind the car. He was not directly next to the car. But again, when we look at a consensual encounter, the test becomes, if we're going to look at it as a consensual encounter, the test becomes, would a reasonable person feel free or feel that they are able to not respond, leave? In this case, I think it's hard to make the argument that the appellant in this case would have felt that she was able to leave. She had a car somewhat behind her, maybe not directly behind her, but somewhat behind her, a police officer's vehicle, with a spotlight shown on the car. And the officer was being accusatory towards her immediately upon her rolling down the window. I think it's hard to make that argument that the appellant would have felt the ability to say, you know what, I'm okay, and I'm gonna go.
So when the officer rolls down the window, or when your client rolls down the window, excuse me, the officer smells the odor of alcohol and also testifies that he sees her physical appearance, the glassy eyes, the bloodshot, so on and so forth. Did he testify that she slurred her speech at all?
I believe he testified that he did, and this is the other part of the argument, okay? Your Honor, the court was able to view the video, and the video was entered into evidence. There was no slurred speech, okay? I mean, that's just, everybody was able to watch the vehicle. There was no slurred speech. I don't even believe that the court cited that in their reasons for allowing this, when you look into the totality of circumstances and allowing to proceed to field sobriety tests. I don't even think they cited slurred speech. The things that were cited were the smell of alcohol emanating from the vehicle, the time of day, the non-believable or non-credible denial of drinking alcohol, which, Your Honor, I don't know where that comes from. I mean, the video clearly showed the appellant was soft-spoken, kind. Obviously, she seemed a little nervous at first, but she didn't fumble with her belongings. She got her license and her registration. I think she got an insurance card out without issue, and proceeded on a normal conversation. She had a reason for being there at that time, stating that she had done paperwork after getting out. She was a manager at the bar. She stated that working at the bar could be the reason that there was a smell of alcohol coming from the vehicle. The officer didn't testify it was coming from the defendant's mouth.
Counsel, then you're starting your rebuttal if you'd like to say that.
Okay, I'll go one more minute here, and I just want to touch on the totality of the circumstances argument as well here. Obviously, totality of circumstances is a tough argument when you look at what gives you the reasonable suspicion to move on to the field sobriety test and what doesn't. In this case, one of two things happened. Either one, the trial court clearly lost its way in viewing the video and then giving the credibility to the officer's testimony that it did, when the video showed that the appellant didn't slur her speech, she didn't fumble with her belongings, she was kind, she didn't seem confused, she had reasonable explanations for the officer's questions, and the court determined that there was a non-credible denial of alcohol, which to me, there's no way for them to come to that conclusion. Or the other way of looking at this is it just wasn't enough. The officer did not have an admission of drinking. All the officer had essentially was a person outside of a bar at 5 in the morning with the smell of alcohol coming from their mouth, or from the car. And again, when you take into account the appellant's responses to the officer's questions, there was not enough in the totality of the circumstances argument to say that this investigation could go from questioning the defendant about drinking to actually having her get out of the car and perform field sobriety tests. Thank you.
May I just ask one more question? When she got out of the car, I thought I read that the officer indicated that she stumbled or that she may have had some difficulty. Is that part of his testimony?
After she got out of the vehicle?
As she was getting out of the vehicle.
I don't recall whether there was that exact testimony. I know there was testimony as to her performance on the field sobriety test.
And the other question is, will we find in the record testimony of the officer that once she got out of the vehicle that, and was away from the car, that he could yet smell the odor of alcohol about the person?
I don't recall that from the record either, Your
All
Honor.
right. We'll look at that.
Thank you.
Thank you.
name is Matt Lanier. May it please the court. I'm here on behalf of the city of Medina. And good morning to you too, Mr. Murray. In response to initially some of the facts, as was testified and reported to by Mr. Murray, I will point out his referral to the officer activating an emergency light. The testimony was a spotlight. So emergency light, could suggest the red and blue takedown lights, and that was what was not used here. It was a spotlight so we could see. The 7 o'clock, the reason that's important as far as how the officer parked in relation to the defendant's vehicle is important because it was not behind the vehicle preventing the vehicle's movement. It was such that when he did turn on the spotlight, he was able to shine the spotlight on the side of the defendant's vehicle before getting out of his car and approaching her vehicle. With regard to slurred speech, Mr. Murray initially indicated there was not slurred speech and then admitted that the officer testified to the slurred speech and then later in the argument testified that there wasn't slurred speech. But
That there was?
That there was not. So Mr. Murray I'm taking that as Mr. Murray's opinion there wasn't slurred speech, but the officer's testimony, and it's in the transcript, was that there was in fact slurred speech on the part of Ms. Hace. The two primary cases that Mr. Murray relies upon for the initial approach are one from the 7th District, State versus Brown, and one from our district, State versus Clapper. And I'm very familiar with State versus Clapper because I was the one that handled it at the trial court level and then at the Court of Appeals level. Those cases are very similar to each other, but different than the case we have here today. Specifically, the main difference being there was a show of force on the part of the officer prior to initiating this consensual encounter. And specifically in Clapper, Trooper Sanko from the State Highway Patrol observed Ms. Clapper's vehicle in a parking space in a rest area, and the brake lights were flashing as though someone's foot was tapping on and off the brake. His theory was that possibly it was a medical situation causing her foot to do that. In any event, this court determined there was a show of force. He activated red and blue takedown lights, which this court determined at that point she was not free to go. When you activate those overhead lights, they're not able to go. Brown was the same way. In the Brown case, although it's the 7th District, it's initiated by an officer who activates red and blue takedown lights. This case is different. Officer Terwilliger from Medina Police Department actually did everything perfect in this case. He's out on patrol. It's 4:59 in the morning. He testifies as to his experience in that area and knows that that establishment closes at 2:30. He's even familiar enough with it to testify that the employees are gone by 3:30, and it's 4:59. There's a car with lights on as he's driving on Court Street, the main drag. This is in an area that he's testifies to. He's patrolling because there's been evidence of sex in vehicles, drug abuse, alcohol in vehicles, so that's why he's in that area. He sees a car with lights on, it's 4:59, he knows the business is closed, he pulls into the parking lot. He does not activate red and blue takedown lights, he does not block the car in. He stops his car at that angle, gets out of the car, and just as he would have been trained, as he approaches the vehicle, gets real close to it, his words were right on top of it, he observes there is a person in there. The windows are frosted, but there's a person sitting in the driver's seat, and he hears the car running. He taps on the window, she rolls the window down. His first words were, what are you doing? Which I agree with this court, and some of the line of questioning, that is not automatically indicative of anything. It would be a common question that an officer would ask in a consensual encounter. During that consensual encounter, he makes other observations. Slurred speech, strong odor of alcoholic beverage, and he doesn't say it's from her breath, he says it's from the vehicle. He goes in to testify regarding his experience, and there is a difference between faint, moderate, and strong. He testified as to kind of the differences as he's learned over the years based on his experience in prior cases. In this case, the testimony was strong. He has to ask her a few times about consumption of alcohol, then he provides, in his opinion, the answer where she denied that he didn't believe it. He said based on the eyes, based on the slurred speech, based on the strong odor, he believed that she had been consuming alcohol. At that point, it does shift to continued detention. With that limited amount of data, that is enough to inquire further as to should she be in physical control of this vehicle. The elements of physical control are in the driver's position with access to the ignition device. In this case, she was in the driver's position, seated in the driver's seat, and not only access to the ignition device, but the vehicle was running. So the final component to physical control under the influence is she under the influence? And the initial contact with her, that encounter, was enough for him to inquire further. And then the continued detention was the request to exit the vehicle. And we're acknowledging at that point, once he's made those observations, he asks her to exit the vehicle. It's a continued detention. Once he's had the conversation, made those observations, she's not free to just get out of the car and walk away. He asks her out, offers her an opportunity to participate in field sobriety tests, which she participates in, and he observes multiple clues on all 3 tests. He testified as to pretty extensive training on how to conduct those tests, as well as experience in conducting them prior to that time. Upon observing those clues, that he reached probable cause, and she was arrested for physical control while under the influence. Didn't get into the suppression hearing, but she was arrested and taken back to the Medina PD and submitted to a breath test. It was not an operating vehicle under the influence case because he had not observed or was unable to ascertain if movement of the vehicle had been made. So it was strictly, this began as a physical control under the influence case. After the decision, they entered a no contest plea to that, and then we're here today. I think that's all I really wanted to touch on. Looking through my notes. Yeah, that's all I need.
Thank you.
Thank you.
You have just a little bit of it, very, very little, just a few seconds.
Thank you, Your Honor. I do want to clear up the issue of the slurred speech. What I presented to you in my argument was that if this court reviews the video, I believe that this court's going to have a hard time finding any slurred speech on the part of the defendant in this case. And other than that, I think that's all I have for you, Your Honor.
Thank
So
you.
thank you very much. I appreciate your time this morning.
No problem. Thank you both for your presentations to the court. The court will take the matter under advisement and issue a written opinion that will be sent to both sides. And you can also check on the website where we release it on our website as well as